Hi students, I'm back here with a short video lecture on law enforcement contacts. In this video we'll be wrapping up law enforcement contacts with the topic of arrest. Just as a reminder, there's three law enforcement contacts: consensual encounter, detention, and arrest. Regarding these contacts, if you were to view them on a scale or spectrum, say, consensual encounter would be the least intrusive type of contact. Remember, consensual encounter has to be voluntary. There is no seizure, so it does not have to be justified under the Fourth Amendment, but it has to be voluntary. The next highest or more intrusive type contact is a detention. The detention is based on reasonable suspicion to believe the person is involved in criminal activity. It's based on facts, not a hunch. Those facts are known before the detention, and the purpose of that detention is to eliminate the suspicion or confirm it. If it's eliminated, they're going to be free to go. If it's confirmed, most likely there will be an arrest. Also, regarding the detention, there are two rules that officers have to follow. It has to be done expeditiously, which is quickly as possible, and the officer has to use the least intrusive means to do it. Now, the highest level of contact, or the most intrusive, which is a better way to put it, is an arrest. And an arrest occurs when the police take a person into custody. And remember, it's either by actual restraint, which means physical force, or the person submits to the authority. And it's valid if the officer had what? Probable cause for the arrest and uses reasonable force to make the arrest. So there's a couple points here. Submission to the authority. A lot of arrests are, I hate to use the word routine because I don't think anything in law enforcement is routine. But a lot of times people will just submit. You tell them you're under arrest and they'll submit. Tell them you have to cuff them up. You're going to cuff them in the back, put them in your car, take them to booking, and they'll be processed. So they'll just voluntarily turn around, cuff up, get in the car, and off to the jail they go. Sometimes it's not that simple. Sometimes, they're going to use force to um, resist. I'll give you an example. I remember stopping uh, an individual. He was actually, his car was stopped in the middle of the street. It was like a street like Blackstone in Fresno. He's in the middle lane. And actually was his legs were, his car door was open, his legs were out. He was sitting in his car seat and he was urinating. Crazy, I know, but that's what I saw. So I just pulled behind him, waited for a few minutes. He got back into his car and started to drive off, and I lit him up and pulled him over. And I gave him field sobriety tests. My sergeant was there, and I formed the opinion that he was driving under the influence of alcohol. And I always try to low key it first. If you low key the contact, it's a lot easier to do it that way, and you can always escalate. The problem is if you start off at a higher level, it's difficult to de-escalate because you have people's emotions in play at that point. It's just hard to de-escalate the situation once you start at a higher level of intrusion. So I just told the guy, you're under arrest, and put your hands behind your back, and I'm going to cuff you up, take you down, and so forth. And he said, no, I'm not going. I said, well, you're under arrest. He goes, no, I'm not. So I grabbed his wrist. My sergeant grabbed a wrist, and this guy was a cement finisher. He was a lot older than me. At that point, he was 40, which is young now, but back then he was older. And he just basically tightened up his arms and his chest, his back, everything. He just became rigid, and we couldn't even move his arms. And we were tugging and tussling. It was more like a passive resistance, not he wasn't assaulting us, but we had to take him into custody. So I ended up using the carotid control. I slipped behind him and wrapped my arm around his neck and applied pressure on his carotid artery, and He passed out. He fell, it was a controlled fall. I had him, but he ended up passing out and going down to his knees, laid him out on the sidewalk, laid him on his stomach and cuffed him up, and then he came to. But he cooperated after that, and he went to jail. It was peaceful, but for a while there, I wasn't sure. But so, and I've been in other situations where it's all out fight. The fight's on, you're fighting them, and you have to do what you got to do if you're a police officer. You're going to take them into custody. So the other point is that there has to be probable cause. This is a different legal standard. Remember, consensual encounter has to be voluntary. A reasonable detention rather requires reasonable suspicion, and an arrest requires probable or reasonable cause. Probable cause or reasonable cause, it's different terms, but it means the same thing. So how is that defined? It's defined as facts known prior to the arrest. Remember, these are facts that are known prior to the arrest, just like in a case of a detention, which causes a reasonable person to believe that a crime has been committed by the person that you're arresting. So you have a reasonable belief that the person committed a crime, then you can go ahead and arrest them. Remember, it's a fair probability of guilt. It's a probability of guilt. You're not 100% sure. It's not absolute. It's not written in stone. It's probable or reasonable cause to believe that this person committed a crime, then you can arrest them. Let me give you an example, and these are examples based on the detention examples I used. And the first one that I used was the car stop where I stopped the car with the motorcycle in the trunk, right? I had reasonable suspicion. I stopped the car and I made efforts to confirm or eliminate the suspicion. And I actually confirmed it when the owner was contacted and said, yes, my motorcycle has been stolen, and I did not give the people that you have stopped permission to possess or to have or take my motorcycle. So at that point, I had probable cause to believe that the person had stolen or possessed the motorcycle, knowing it was stolen. So I had probable cause to believe that this person committed a crime, and therefore I arrested that person for the crime. The other example that I used was the robbery or the theft from the mini market, and it was a beer run was my example, and the clerk called 911, gave a description. An officer saw the individual on the bike matching the description, detained that person, and there was an identification made. Once that identification was made, there were different ways to do it, by the victim or by watching a video, different ways to do it. But once that identification was made, that established that that person was the person that committed that crime, the officer had probable cause to arrest him. The officer had probable cause to believe that person committed that crime, then that person can be arrested. So that's how that kind of works. Now, everybody has some authority to arrest. The authority is regulated by the Constitution, which requires probable or reasonable cause. But there's also another layer. There's a layer of state laws which grant authority to the police and also to you as a citizen the power of arrest. Now, you might have, as a citizen, the power of arrest. Do I recommend that you go out there and start looking for criminals to arrest? No, don't do that. That's dangerous, and it's better to be a good witness than put yourself into harm's way. Don't do that. These folks out there today, you never know what they have on them. You don't know if they have a knife, a gun, another weapon. They might be under the influence. They might have needles or other things on them that you do not want to have contact with. So don't do that. The only time I would say is if it's absolutely necessary, and you just have to judge that by the circumstances. If it was an emerging situation and you just needed to do it, then you have the authority to do that. So you would detain or arrest them, call the police would come, and either they'll arrest them or they'll ask you to make a citizen's arrest. That's how it works. So most arrests, where do they occur? Most arrests occur in the public, and most arrests actually occur without a warrant, just based on probable cause. But if you're going to choose to arrest somebody in their home, what do you need to do that? Well, you're going to need an arrest warrant to arrest someone in their home. That's a requirement, unless what? Unless there's some sort of an exception to the requirement for an arrest warrant. What would be an exception? Well, one would be, and a frequent one is exigent circumstances. Exigent means it's an emergency. For example, if the officer gets a 911 call regarding domestic violence and responds to that call, and as he's approaching the house, he can hear the suspect beating up on the victim. Can the officer then enter that house? Yes. Can the officer enter the house and arrest that perpetrator without an arrest warrant? Absolutely, absolutely. That's done quite a bit. If there's a call of some other kind of crime, assault or a burglary, and the officer responds and he goes to that house and the assault is taking place, just like the domestic violence, or there's a burglary suspect in there, or the officer can enter that home without a warrant and arrest the perpetrator without a warrant. Another other exceptions would be hot pursuit. You chase someone into the home, and that person is wanted for a crime that they committed outside of the home. They ran from the officer, and the officer chased them in. That would be hot pursuit. They could go in and arrest without a warrant. Preventing escape or destruction of evidence, that would be another exception. And also consent. So sometimes it's interesting. You have a probable cause to arrest somebody for a crime, and you locate their home, you go to the house, and maybe it's a juvenile. That happens quite a bit. You tell the parent, you have reason to believe that their son or daughter committed a crime, and you want to come in and take them into custody. A lot of times parents will allow you to do that. It's their home. They control the home. The kid doesn't own the home, have control over the home. The parent could give consent to do that. That happens as well. What about a third party's home? Say you want to arrest me and I'm not in my home, but I'm at my sister's house. And what would you need to arrest me in my sister's house? Well, you need an arrest warrant for me, but also then you would need a search warrant to search my sister's house to find me. So you'd need two different warrants, an arrest warrant for me and a search warrant for my sister's house. And again, there are exceptions. If there's consent, if you went to my sister's house and asked my sister, can I come in? Your brother's in there. We have probable cause to arrest him. We want to arrest him. So, I mean, my sister could give consent. It just depends on if she's mad at me that particular day, or she might be, uh, protective. I mean, she might say, no, you can't do that. And then there's also the exigent circumstances and the other ones that I mentioned to you. So that kind of leads to a question. Remember, if you're a police officer, you should always be thinking of what? Get a warrant. Why? A warrant is issued by a judge. A search warrant is, which we'll be talking about coming up, or even an arrest warrant. The judge has already reviewed all the documentation, and the judge has made a finding of probable cause. The judge has already determined that. And in the case of an arrest warrant, the judge is issuing an order to a police officer to locate that person, arrest him, and to basically bring him before the judge. All that means is he's going to be booked into jail until he's brought over for his initial hearing on the warrant, which is called an arraignment. But there's a judicial determination. When an officer is acting under the authority of a warrant, remember that action of the officer is presumed to be lawful. The burden's going to shift over to the defendant to show that it's unlawful. That's why it's always better if an officer can get a warrant, either an arrest warrant or a search warrant. It's absolutely the best way to go. But again, that's not always practical. That's not always available. So that's why the officers need to understand the exceptions, because they know and should know that if they are acting without a warrant, then that particular action is going to be presumed to be unlawful, and the burden of showing that it was lawful is going to be on the prosecutor, on the people, on the officer. So that officer is going to be called to testify if there's a motion to suppress. And so he better be able to remember what happened, testify about what happened. He better have written his report accurately and be able to testify, because the burden is going to be on the people to justify any action that's taken without a warrant. And that's very important to know. I want to also mention use of force. Use of force has to be reasonable. Officers, part of their training is on how to use reasonable force to make an arrest. And generally speaking, you're going to start with a low level of force. Sometimes it's just by telling a person you're under arrest, turn around, put your hands behind your back or wherever you want the hands, and cuff them up and put them in your car. It's as simple as that. Other times, a person might be, not combative, but not particularly pleased that they're going to be arrested. So you might have to use some sort of control hold. Officers, like myself in the police academy, we learned what we called pain compliance holds. It was like a wrist lock, a twist lock, those kind of holds. And we weren't there to beat people up, believe me. I mean, if a person became combative, then that changes the whole situation. But you have tools on your belt that you can use. You can use pepper spray. That's what we had. We didn't have tasers, but there's tasers now. We had a baton, of course. We could use that. Um, but the force has to be reasonable. You're not there to beat them up. But the amount of force has to be a higher level than the force that the person is resisting you with, right? Because the officer ultimately has to win. His force has to trump or be a little bit greater than the force being used by the perpetrator, right? Because at the end of the day, that guy is going to have to go to jail, and in order to get him to jail, that the force that he's using has to be overcome by the police officer. So it has to be a little bit higher of a level of force. What about the use of deadly force? Unfortunately, there are circumstances that uh, require the use of deadly force. Generally, the test is that the officer has to reasonably believe that there's imminent danger of great bodily injury or death to him. So it's imminent danger. It means it's happening right now. Imminent danger. The threat is immediate. It's right there in front of you. It's imminent. It's going to happen. And it's an imminent danger of what? Great bodily injury or death, not only to the officer, but to other people. So the officer can use deadly force not only to protect the officer, but he can use deadly force to protect somebody else. As far as deadly force, I was trained, and I know other officers are trained. When you use deadly force, which is typically going to be your handgun, your side firearm, you're gonna shoot that firearm to stop that person. You're not trained to shoot the arm or the hand or the foot or no. You're taught to shoot center mass. Why? Because center mass is the area where you could stop a person. And just because you hit them center mass doesn't even mean necessarily that they're going to stop. I mean, um, the other issue that comes up is you have multiple officers, and people wonder, well, why do the officers have to shoot them 20 times? Well, the reason for that usually is that let's say you have 4 or 5 officers there, and the person makes a threat. Each officer is going to act independently of the other officers. They're not going to sit there and have a little discussion beforehand with each other, decide, okay, well, if something happens, you shoot, No, it does not work like that. They're all going to react and they're all going to respond appropriately. And it's just because of that that sometimes there's multiple shots fired. And people don't understand that sometimes. The other thing, sometimes it's even better if a person is resisting that there's multiple officers there. It kind of looks like a dog pile, but if you can take down a person quickly with multiple officers and get them cuffed up, sometimes that's better not only for the officers, but it's better for the person because then you avoid a situation where it's the perpetrator and one officer just battling it out because in that case there's a higher risk that the officer or the perpetrator is going to be injured. But when you can overwhelm that person with quick and overwhelming power, then you can take that person into custody fairly quickly and avoid, a prolonged battle and higher likelihood of somebody being injured. So that's not a bad thing. There are a couple cases on the use of force in your book I just wanted to mention. Tennessee versus Garner was a case where the officers responded to a prowler. They responded to this home. They went into the backyard. There's a young black kid. He was fleeing from the officers. The officers were telling him to stop. He refused to stop. He was climbing over a fence and fleeing from him. And one officer shot him in the back. Turned out he was not armed, but he was involved in the burglary. And ultimately, that was a use of force case, and the question was that a reasonable use of deadly force. What do you think? No, the court said no, it was not. There was no what? Imminent danger. There was no imminent danger to the officer or to anybody else at that point, right? I mean, the kid's his back was to him. He didn't have a weapon. He wasn't pointing a weapon. There's no imminent danger to the officer or to anybody else for that matter. So it was a violation of the Constitution. Remember, use of force is governed by the Fourth Amendment. You're talking about use of force is a seizure of that person. Any use of force on a person is a seizure of that person, and it's going to have to be justified under the Fourth Amendment, which means what? It has to be reasonable. Another case was the use of that PIT, PIT maneuver. PIT is an acronym. I'm not sure the acronym, what it means. It's like pursuit, intervention, technique, or termination. It's something like that. But it involved a high-speed chase. And back in my day, we just chased them until they crashed. And then, you know, it, or they stopped. Generally, we didn't run into them, but there is a technique that officers are taught where they can pull up alongside the rear quarter panel and use the front of their car to hit the rear axle, which causes the car to spin backwards and stall. That's the technique. It's used very successfully to end pursuits, honestly. In this particular case, it was up in the Pacific Northwest. There was a pursuit, high speed. It was a rainy two-lane road. The guy was driving like a maniac, passing cars on this, running cars off the road. It was going on and on and on. And finally, they used that technique, and the suspect's vehicle flipped off the road and he was severely injured. He was a paraplegic, paraplegic or quadriplegic. So he filed a lawsuit, and the question in this lawsuit against these officers was whether or not that use of force was reasonable under the Fourth Amendment. So it goes up all the way to the U.S. Supreme Court as a 2007 case, and the U.S. Supreme Court they commented all the facts that I mentioned, and I don't know if the U.S. Supreme Court watched the videos, but the lower courts did, and they not only watched. What video am I talking about? Well, dashboard camera video in the police car showed it all, and they watched it, and they said, this use of force was reasonable under those circumstances. The officers had no idea of the consequences. They didn't. I mean, it's risky, but they didn't know this person was going to be severely injured or even if he was killed. But, he was putting a lot of people at risk, driving on a 2-lane road, high speed. It was wet and rainy and running people off the road. It had to end before someone was killed, and it was an imminent, people were at imminent danger of great bodily injury or death if that pursuit continued, and the court said this was a reasonable use of force. So these issues are always coming up. I mean, you're watching the news, and these riots in some of these cases have. The Floyd case is one that just comes to mind that I've been watching. I didn't really watch all of it, but the officer, Chavin, I think is his name, had arrested this guy, and they had worked together, I believe, as bouncers in a bar before. But anyway, he had arrested him for something, and Floyd did. He wasn't a he had a criminal history, a little bit of one. I'm not saying that justifies it, but he, I think he was doing a little bit of resisting, is my recollection. And the officer pulled him out, put him on the ground, and I've done that. I've put people in my car, and they start kicking out my window. I've had to pull them out of my car, and sometimes hog tie them. I mean, there's different things you can do with them, but in this case, he pulled him out of the car, put him down, belly down, and knelt on his neck, and then you know what happened. But was that unreasonable? Yeah, probably. Yeah, probably unreasonable use of force. And as a result of that, the officer has been charged, and other officers have been charged. So we'll have to, wait and see what happens there. But anyway, that ends this video. That ends law enforcement contacts. I hope you've been able to learn more about them, and we're going to be moving into the next unit, Unit 4, and it's on Chapter 4, right? And it's going to be on search and seizure. So we're going to be talking about search warrants and the exceptions to the search warrant. So look for those videos, and stay safe, and I'll talk to you soon. Bye-bye.